first matter to come before us this morning is the A. Morgan Building Group versus Owners Insurance Company and M&M Welding LLC. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time, please let me know when you get started. I'm keeping the clock. You can also reference the clock on the wall over there. Please, these arguments are being recorded. They will be posted on the court's YouTube channel. Please remain behind the podium and do not use the names of any minors or victims. Though I don't think that's relevant to this case, we always like to make them advise them. The judges have read your briefs, and we are ready to proceed when you are.
Thank you, Your Honor. And before I get started, I would like to reserve 5 minutes for rebuttal.
Certainly, thank you.
Good morning, may it please the court, counsel, Brian Winchester here for Appellant Owners Insurance Company. We're here on an attorney-client privilege issue, and as I prepared for this argument, what I thought I was going to start with is insurance companies are people too. But that one doesn't necessarily fly, but they are recognized specifically under the attorney-client privilege statute. The other thought I had was, let's talk about the history of the attorney-client privilege. Well, uniquely and specifically related to insurance bad faith claims, we've got a 20-some-year history where we have the Ohio Supreme Court in Boone versus Van Liner in 2001 creating exceptions to the attorney-client privilege. And the Ohio Supreme Court again recognizing later in Squire Sanders versus Givadon that the attorney-client privilege is not only defined by statute but also by common law. And what we have here was, in response to the Ohio Supreme Court decision in Boone versus Van Liner, the legislature amended the statute in 2006 to include some specific language, specifically I believe it's subsection A2 or O2A. And when I look at the legislative history for that portion of the statute, what they added was some very critical language in insurance bad faith claims, quote, where it is alleged that the attorney aided or furthered an ongoing or future commission of insurance bad faith by the client, the party seeking waiver must make a prima facie showing privilege should be waived. So what we had here was a trial court conducting an in-camera inspection on not one but two separate occasions, doing a 180 on the eve of trial, and allowing then for disclosure of the attorney-client communications. And in addressing that, by the way, I believe we are here on a de novo review under Northeast Monarch versus Morganti, and also I believe followed last year by this court in State Auto versus Rowe. So there's no deference needed to the trial court's findings and determinations. And what the trial court did, or what it didn't do, was it relied upon a Second District Court of Appeals, GARG, to say that those attorney-client communications may tend to cast light on bad faith. Not the language of the statute. The language of the statute is abundantly clear. It's specifically related to the attorney's aiding or furthering an ongoing or future commission of bad faith by the client. In this case, there is no such argument. There's no such finding by the trial court. In fact, if we look at Appellee's brief in this matter at page 35, it was specifically stated, Morgan is not accusing Mr. Winchester of aiding or furthering owner's commission of bad faith. That's it. It's acknowledged, it's waived. They don't meet the elements of the statute. The trial court did not. Appellee acknowledges that there is no allegation of aiding or furthering the commission of bad faith. So that standard from the GARG case predates the amendment to the statute and should not be followed by either the trial court or this court. In this instance, as a reviewing court, you have two separate options. One, remand to the trial court to apply the proper standard, or two, on a de novo review, reverse the trial court's entry. They specifically did not make any finding of the attorney made aiding or furthering an ongoing or future commission of bad faith by the client. There have been a lot of cases throughout the state that address attorney-client privilege, including late last year, the Ohio Supreme Court in a criminal case, gave a very succinct statement on the sanctity of the attorney-client privilege, which is exactly what Applee is seeking to do. And that was in State versus Brunson. The attorney-client privilege is one of the oldest recognized privileges. It encourages full and frank communication between clients. We don't have that in this instance. We have a trial court seeking to invade the attorney-client privilege by finding that it may, quote, tend to cast light, not an aiding or abetting, which is exactly what the language of the privilege statute now says, following Boone versus Van Liner. So in this case, again, two options, reverse or remand. And we would request that it just be reversed because based upon this court's status as a reviewing court, you are entitled to do that on a de novo review. And with that, I'll see the remainder of this portion, although I've only got 10 seconds, unless I have questions, Your Honor.
I have a question. Back to the Boone versus Van Liner case. When did the denial of coverage occur?
August of 2019. It's specifically alleged in plaintiff's complaint. And if you read the pleadings in this matter, in fact, if I look at the timeline of the pleadings, there's many of them. Not a single one alleges the attorney may aided or abetted anything in relation to bad faith. So there's no allegation within the complaint. So we had a federal court complaint in March of 19, amended in April 1 of 19. We have a state court complaint in July of 19. We have an amended complaint in November of 2019. In that pleading, they allege a denial of coverage in August of 2019. But the unique posture of this case from a factual history is this has been adversarial with both sides represented by counsel since 2 months after this loss. Attorney Myers has been on this claim just about as long as I have, and we went through the process under the policy of examinations under oath prior to the first filing in federal court. So that's part of that process. And again, it's not like my presence in the case was a secret. There's no allegation of aiding or abetting, and it just doesn't meet the elements of the statute. And again, I will take a seat unless there are additional questions.
Seeing none, thank you.
Thank you.
Good morning, Your Honors. Please the court. My name is Ken Myers. I'm assisted by Justin Alberta. We're here on behalf of the plaintiff, Applee, A. Building Group. I'd like to address what it seems like Mr. Winchester's main point was, which was that the statute applies and that we don't meet the elements of the statute. The statute he's referring to, I believe, is Ohio Revised Code 2317.02. And the A2 section of that starts out with, the following persons shall not testify in certain respects. Then it goes on to list all the situations in which attorneys shall not testify. That's not where we're at. That's not what this case is about. That's not the procedure or the posture we're in right now. What we're talking about is in the discovery phase of the case, is whether or not claims notes, certain portions of claim notes, have an attorney-client privilege, and that's where we go back to Boone. And the language of Boone is very clear. That says, we hold that an action alleging bad faith denial of insurance coverage, that in an action alleging bad faith, the insured is entitled to discover claims file materials containing attorney-client communications related to the issue of coverage that were created prior to the denial of coverage. And that's what we asked for. There was a long list of redacted claims notes. I mean, we got a whole list of claims notes initially, and a bunch of them were redacted that showed communications between the claims agent, Ms. Pettigrew, and Mr. Winchester. And we initially asked for those. The court denied them at this stage when we were still in the middle of discovery. Now, what happened between then and the court giving a different view of it was that we deposed Ms. Pettigrew, who said under oath in her deposition that she was the decision maker who denied the claim, and the claim was denied a year after the fire. I think that's important to note. So that's almost prima facie bad faith. There was a year went by between the fire that's in question and the denial of coverage. But Ms. Pettigrew testified that she was the decision maker to deny the claim. But when I asked her why to deny the claim, she said on advice of counsel. And so we now know, we knew that after that there were 90-some redactions that indicated communications between Ms. Pettigrew and Mr. Winchester. Then the court denied summary judgment, not only on the underlying breach of contract claim, but the bad faith claim. So now we're getting ready for trial after the denial of summary judgment, and we made another request to the judge saying, hey, now we're in a different posture. Now we know that Ms. Pettigrew made the decision, but she won't tell us why. She won't tell us why the decision was made that relates directly to our bad faith claim. And we know there's 90-some indications that she spoke with the attorney, who now she says is the one that advised her to deny the claim. So we're facing.
Did she say she would not tell you, or that she could not remember?
No, she wouldn't tell us on advice of counsel.
Did she say it was based on her own investigation?
She said that it was her own investigation and on advice of counsel.
Okay.
And then in the deposition, counsel advised her not to answer any further questions regarding any discussions she had with counsel. So we asked for the claims notes again. Now, we asked for them 6 months before trial, right after summary judgment was denied. The court didn't make a ruling until the week before trial. I think that point, the eve of trial issue that Mr. Winchester raised is moot because we're no longer at the eve of trial. This appeal was filed. Whatever the court decides, if the court affirms, then the court will set a new trial date. And we will certainly ask to, in a limited way, reopen discovery so we can find out if there's any other information in addition to the redactions. But the point is that the statute that Mr. Winchester would like to have this court rule on does not apply, because we're not asking for the testimony of Mr. Winchester. We're not asking for his internal notes. We're asking for the notes that the claims agent wrote based on her conversations with Mr. Winchester that led to the denial of the claim and other delays in the claim. And so Boone and the subsequent case law, which very clearly states that there is no attorney-client privilege when it comes to bad faith claims, that's what applies. And what the judge did, what the trial judge did, was applied a process. It wasn't just a blanket, you're going to get them all or you're not going to get them all. What she did was she said, I'm going to do an in-camera inspection, and I'm going to look at them individually. And what she did was she gave us most of them, but she denied some of them. So she made an entry-by-entry determination as to which claims notes we were entitled to and which didn't apply. And so if the court were to rule based on the statute, the court would really be ruling on something that we didn't ask for. We're not at that stage yet. Now, if we get the claims notes and we find out that there is some indication that Mr. Winchester engaged in the determination of bad faith or something else, then we'll move it along that process, and maybe in 6 months or a year we'll be back here on that question. But we're not there yet. And the statute did not modify Boone in a way that made it irrelevant or obtuse. It actually made it so that the only amendment that makes a difference in this case is that the statute said it doesn't just, the lack of attorney-client privilege doesn't just apply to before the denial of the claim. And what we're claiming in this case is it's not just the denial of the claim 1 year later that's our bad faith claim. We're alleging that in the whole course of things, during that whole year before the denial, there were delays and there were other elements of bad faith. And even after the denial, there were indications of bad faith. So we think that the scope of these redactions will show over the months between the fire and the denial that there were numerous communications. We can only guess at what's behind them. We don't know. Mr. Winchester knows, the trial court knows. This court has the ability to know by reading them. But what we do know is that there was this lengthy delay in denial, that Mr. Winchester entered the picture. Ms. Pettigrew testified that in the first month after the fire, and she did a lengthy review and investigation, and she testified that she was ready to settle the claim. And she testified that she advised the owner of A. Morgan not to get an attorney, not to get an appraiser or an advocate, that she was ready to settle with him. And then all of a sudden, Mr. Winchester pops up, and then we hear stone silence. And there's, in the record, 7 different occasions where A. Morgan wrote to or had communication with the insurance company, with owners, saying, what's the status of the claim? Can we have an advance so we can patch over the roof before the winter? Can we have, something? Nothing. And this is all during the time that Ms. Pettigrew is communicating with Mr. Winchester, which we didn't know at the time, or we didn't know what the communications were. And then after 8 months, we got sick of hearing nothing, we filed a lawsuit. It wasn't until 4 months after that that they formally denied the claim based on what we think is sort of a questionable reason, in which the trial judge found where there was at least a reasonable question of fact about the validity of the reason for the denial. So we see a scenario where if we don't get these claims notes and we end up going to trial and we either lose the bad faith or we get a minimal amount of the bad faith, then we later come to find out that these claims notes contain a lot of additional evidence of bad faith, I think that'll be very prejudicial. And again, I think it really comes down to the facts. Is there or is there not an indication of bad faith in these claims notes? And this court certainly, either you've already read them or you have the ability to read them. I would urge you to read them because I think they'll be dispositive. I think it'll back up what the trial court found, which was that there's, of 90-some entries, the majority of them tended to show or tended to cast light.
Are you asking us to make a decision based on the fact of those entries or just on the law that exists now and your right to discovery of this?
Well, both. I think if you go through these entries and you find it's totally innocuous, every conversation they're talking about is just scheduling or something procedural, then I think that you would be within your right to say it doesn't tend to show bad faith and we're not going to turn them over, and the right of attorney-client privilege prevails. But I think that there's enough, from what we know, I just elucidated all the sort of circumstantial facts that show that there was something in there that tended to show bad faith. The trial judge found after a review that there tended to show bad faith or tended to support it. And remember, we're only talking about discovery here. So we only have to show that we are entitled to it if there's something that leads to the discovery of relevant information. We're not talking about whether it's admissible at trial. That's a whole different question. So if we get the claims notes, then I expect that we'll have additional battles before trial with whether they're admissible or how many of them are admissible. But that's not, in front of this court. Right now we're talking about, in discovery, are we entitled to these claims notes? And Boone very clearly says, and the progeny of Boone very clearly says, that we are entitled to them. Now the court, trial court, I do think was wise in building in this in-camera review as opposed to just blanketly giving them to us. I think if the court blanketly gave to us, then there'd be more room to question whether there are any exceptions to the exceptions. What do we have to prove? But the court went through them, did her due diligence, whether it was in 19 or in 20, whether it was 1 year earlier, 1 year later, doesn't make a difference because the court wasn't bound by the earlier decision to not give them to us at that stage. She very clearly said, at this stage. We came back to her at a later stage, and she said, you know what? given all that's transpired, I think you deserve them, because now I've looked at them more carefully in light of the denial of summary judgment and the question of facts, and I think you ought to have those. And that's what she said. And I think that that's what this court should affirm.
I have a question for you, counsel. It's the same question I asked opposing counsel. So, I think I heard it, but do you not believe that Boone versus Van Laner stands for the proposition that you're only entitled to those documents that were created prior to denial of coverage?
I think that Boone, that's what Boone says, yes. Now,
Okay.
statute modifies that, but I believe that all the claims notes that are relevant to this issue did occur prior to the denial, so whatever the statute modified is not relevant. So yes, Boone gives us the right to everything that goes from the fire, which was August of 18, to the denial, which was September of 19. And I think that's all encompassed. That's all that the claims notes, that the period of the claims notes
Yeah.
show.
Thank you.
Okay, thank you.
Thank you, counsel.
Thank you, Your Honor.
You have your full 5 minutes to follow.
I will hopefully not use all of that, but if there are questions, please feel free. This is very simple again. The trial court applied the wrong standard. Opposing counsel is making the wrong argument. This tending to cast light standard is a Second District Court of Appeals decision that predates the 2006 amendment to the attorney-client privilege statute. Revised Code Section 2317.02A2 was amended, and the General Assembly specifically recognized Boone and Payco v. Frederick, but says it was modified accordingly. And that's where the language in the statute now says that the attorney aided or furthered an ongoing or future occurrence or commission of
Counsel
bad
seems
faith.
to suggest in his argument that statute only applies to the testimony of counsel and not discovery. Would you agree that the statute you're citing just deals with the issue of testimony of the attorney and not discovery of the bad faith evidence, for want of a better way to describe it?
As to the narrative of testimony, yes, but as recognized by the Supreme Court in Squire Sanders versus Givadon and State Auto versus Roe by this court just last year, that protection in the review is the same to protect those claim notes. Not just my testimony, but also the client writing down their communications with me. So we're under the same review, and again, this would follow last year's decision in State Auto versus Roe out of this court. Again, it's the wrong standard, and I looked through it this morning in opposing counsel's brief, and that phrase "tend to cast light" is used probably 15 times, and was used probably 4 times during oral argument today. That's not the standard, and that was the standard the trial court applied. That is not the standard this court should apply in its de novo review of this privilege issue. And with that, I thank the court for your time. And if there are any other questions, I'd be glad to take them.
Seeing none, thank you.
Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed by the clerk to all parties to this appeal, as well as posted on the House Supreme Court website.